That's taping. All right, I'm going to roll sound right now. Who's going to do the intro?
You can do it.
Okay. Well, good morning, everyone. Welcome to the Bottled Business Sense Show. I am Rick Moscoso here, and it is Tuesday at 10:30. Looking forward to a great episode here. But before we get into that, I want to introduce my co-host, Bill Bernard, who's on the other side, and welcome him to the show. Bill, how are you doing today?
Thanks, Rick. Good morning. And by the way, it is 10 a.m. 10:30 would put us at the end of the show. So we don't want to rush it. We don't want to rush it. We want to take our time. But I'm doing fine, and had a real busy week this week, or last week, I guess I should say, and looking forward to doing another show because at our show, the Bottle Business Sense Show, it's all geared toward the entrepreneur, the small business that sails along and attempts to make a great profit while also being protected from all of the unsavory outside influences that we run into in the course of our business. Having said that, Rick, your input in the show is to help promote a business and to help it keep sailing along by utilizing great marketing tools. And mine, on the other hand, is to provide a legal perspective, help our small business owners avoid any pitfalls. But I should always mention that this is legal educational information. It is not in any way, shape, or form creating an attorney-client relationship between any of our viewers and listeners or myself. Because specific facts and case scenarios need to be examined closely before a lawyer can comment specifically on an individual's particular situation. So having said that and gotten the disclaimer out of the way, as all good lawyers should, the show today, Rick, really centers around the following best asset protection planning rules. Are you, the listener, the viewer, are you following the best asset protection planning rules that you can? And in order to do that, it's always helpful, of course, to know what they are. And so we're going to cover some of those today. But I wanted to start off, Rick, with the general premise that everybody listening and watching should remember the following. Start early and don't try to hide stuff. Start early and don't try to hide stuff. That means you don't wait till a lawsuit's coming down the pike to do asset protection, and it doesn't mean that you have to make sure that nobody knows what you have or where you have it, because proper asset protection planning avoids that requirement.
Well, that makes total sense, because by the time, if someone hasn't done it early and you get in a situation where you do get in a lawsuit, it's almost too late to try and get it straight.
Well, that's true, but we're going to cover another major scenario there that comes into play that feeds off of what you just said. But But let me start off by saying that, those who worry about asset protection are usually people that are most likely to get sued. I mean, a lot of my clients are high liability clients. Give you a good example: some nursing care facilities where you take in the elderly and you care for them. Either an employee is problematic and complaining about whatever they might have to do potentially, or someone like a patient gets hurt and wants to sue the facility. Gun owners, or I should say gun manufacturers and gun retailers would be another one. Construction companies would be another one. So people that are worried about getting sued are real critical patients, if you will, that need to be administered some asset protection care, as well as the average individual who's starting up a business. And we've talked about some of that on prior shows. But think of the high liability. I was talking about some high liability businesses. Think about obstetricians and real estate investors. Really, two classes of people or businesses, I should say, that get sued quite frequently. So it's always really behooves the individual to plan ahead. And it's like when you're gambling and you win some money, you take the chips off the table that you win, and now you play with a certain amount. You make sure that you cut your losses. That's really what asset protection is about, and that's what we're going to discuss today. Because remember, asset protection, Rick, is not just about losing your assets. It's also about ending up in jail for contempt or for bankruptcy fraud. And we'll get into how that plays into this. So you can create yourself, you could get into a real tizzy here if you don't do what you should do. So let's talk about the first one, which is planning before a claim or a crisis arise. So many people think, the point when I have to worry is when somebody serves me with a lawsuit, process server shows up at my door, or when I hear that a lawsuit's been filed against me. No, a claim can start long before that, when a dispute of some sort begins, or where you even suspect that a dispute is going to arise. That's why you plan ahead. You don't do asset protection after the fact. You do it before the fact. Can't stress that enough. So I guess if we were discussing rules and we wanted to put them in numerical order, that'd be number one. Plan early. Because if you don't, what happens? What did you just talk about earlier, Rick?
Yeah,
it could be undone, right?
That's right.
And how is it undone? But by being called a fraudulent transfer. The Uniform Fraudulent Transfer Act provides that if you attempt to protect assets after a claim has arisen, and it can be proven that you did it specifically to hide your assets so the claimant could not recover them, you face the potential of having whatever transaction you took part in, having it reversed by the court. Courts are very, very particular. They smell this stuff out. They say, wait a minute, this doesn't make common sense. This in the words of my cousin Vinny, this just doesn't hold water. So you gotta be really careful and make sure that you don't have whatever asset protection you've implemented overturned because you waited too long to do it, or because you did something wrong in some attempt to hide it. Now, remember, another issue. You have a company and you put assets in your company and you don't keep your books. Maybe it's a shell company. Maybe it's really not a company. Well, whatever is in there can then be gotten by a claimant if they can prove an alter ego theory, meaning that this company is just your own alter ego. It's really you. It's not really a company.
Mhm. Now, this is really important for our viewers because, if, like Bill said, if you're not planning early, what are the potential results of something like this? If you didn't plan early, and then there
Mm-hmm.
was an impending lawsuit that they found you knowledgeable about, and then you went and tried an item, what could be the consequences of that?
Well, the consequences could be that the transaction is null and void, whatever you did, and the consequences could be if you attempted to defraud somebody, well, then you face potential fraud charges, which I would say most often would come in by way of a civil claim. Now, if you have somebody filing a lawsuit against you and you want to recover their assets, you win the lawsuit, you want to recover whatever money they have, whatever assets they have. Remember that pursuant to the Fraudulent Transfer Act, you have to bring a claim under the Fraudulent Transfer Act, which would be a separate claim. So you recover against Joe Blow for breach of contract and fraud. Now you're going to get awarded $1 million. Well, he's only got 500,000, but he's got another 500,000 that he deferred or transferred somewhere, either offshore or whatever it may be, to hide the assets because he knew about the lawsuit. You then have to bring a fraudulent separate claim under the Fraudulent Transfer Act to say, here I'm proving up the fact that this was a fraudulent transfer. Now give me access to the other 500,000 so I can complete my $1 million award. Okay, so it goes something along those lines. But remember, here's rule number 2, if you will. Whatever you do that's wrong will usually backfire, even though you think it might be correct. So remember that both the debtor and whoever assisted them in completing a fraudulent transfer could become liable for the creditor's attorney's fees because the creditor had to spend legal fees to come after you. So it's not just you, but anybody who participated in helping you hide these assets will get in trouble. And don't think about bankruptcy, because if you try to go that route, you could be convicted of bankruptcy fraud. The bankruptcy court will not discharge assets that they find were potentially transferred in a fraudulent manner.
Now, what if the the people around you that did this were not knowledgeable about your potential fraud, but executed your wishes to?
Well, you're always going to have to prove. You're going to have to prove a fraudulent transfer, and that requires intent. So if there was no intent, if they had no knowledge about what was going on or the reasons that you had for hiding these assets, well, then of course they're going to be okay. But the point here is to indicate that there is extensive liability that kind of mushrooms out, if you will, if you're not careful, or if you try to get someone's assistance to help you hide these assets once a problem is already made aware. Remember, it's important, I think, to point out as well, and we might call this number 3, asset protection planning is not a substitute for insurance. And we talked about that in a whole program. I'm just going to mention it briefly here. It should instead supplement your insurance. Make sure you have liability and or professional insurance if you're a professional. It supplements asset protection planning since it can help a debtor survive a claim for fraudulent transfer. In other words, if you get sued and you have insurance, let your insurance company pay to defend it or pay to settle the lawsuit. Okay? If you have an issue, you can submit it to your insurance company, and many times they will pay to have this lawsuit defended if it's something that is within the bounds and confines of their policy. So remember, again, that asset protection is not a substitute for insurance, but rather a supplement for insurance. And if you need any further information on that, go and look up our show that talked about the distinctions between liability insurance and business entity protection.
Yeah, that episode, just in case you want to go back and look, you can see it right here on this website, and it was broadcast on January 20th of this year. Liability insurance and entity liability protection, is there a difference? That's the episode, right?
Right. Now, number 4, very important. Personal assets are for trusts. Business assets are for business entities. Very, very, very important. We've talked about this in a number of shows, and I'll show you where they overlap in a manner of speaking. And of course, this is why I've always said that an asset protection lawyer should be an estate planning lawyer, and an estate planning lawyer should be an asset protection lawyer. You've heard me say that multiple times. So business entities such as corporations, LLCs, they're vehicles for commercial operation. They're not piggy banks for your personal assets. You don't stick your personal assets in there, because then you're commingling assets, right? Again, operating company keeps its books correctly. Mm-hmm. When personal assets are placed in business entities, everyone, the potential for the entity for the being pierced by a creditor on an alter ego theory increases exponentially. Okay? It's critical to remember that and understand that. Now, if you want to use a living trust to help protect assets, you would go by way of the irrevocable living trust, where you're actually provide the assets that you own to the trust. And now the trust now owns the assets. You no longer own them. And that is a whole different scenario that, again, I think we talked about in a prior show, Rick, early on when we discussed, I believe we discussed the distinctions between trusts. And I think we may have even had a show on irrevocable trusts by themselves. I'm not quite remembering whether we did or not, but I think we did talk about asset protection trusts. In fact, I'm almost positive. So whatever show that might be can be found on our website in our library. Mm-hmm. We'll call this. And by the way, as a pickup on what I just said about business entities, remember not to call your LLC or your corporation a family LLC. Unless your family is famous for making sausage or some special pizza or whatever, you kind of want to stay away from naming your business in the title a family-owned business. It creates too much convolution, calls into question whether or not this is really a company. It's not a be-all and end-all. As long as you keep the looking, but why put in the name of your business? You can have a family-owned business, as I think we discussed with Ms. Mallory here a show ago, but name it a proper name. Just use a name without the word family being included in it. And remember that too much control is a bad thing. I mean, asset protection planning, folks, is attempts to reach a balance between sufficient control so that your assets don't disappear, but at the same time, not so much control that a creditor can successfully argue that the debtor and the asset protection structure are effectively one and the same. You want to be able to have some control over your assets, but don't feel that you have to have total control all the time. You want to be able to put your personal assets where they're supposed to be put, your business assets where they're supposed to be put. And if there comes a time where you really want to secure those personal assets, make sure that you're insured properly, and make sure, if you need to, if your estate is that big, go ahead and inquire about what is involved in getting an irrevocable living trust as opposed to a revocable trust.
Right. And that's obviously something that Bill can help out with. So as we, as situation arises, or you're in a particular situation where you may need this, Bill, Bill's a great resource for you, and he'll give his contact information towards the end of the show. But Bill, before we go on, why don't we talk a little bit about our sponsor today? And
Okay.
That would be Mr. Bill Pyatt of New York Life.
Right. Bill Pyatt is, people hear the word New York Life and they think, oh, life insurance. That is far from the only thing this gentleman does. He provides, he is a wealth of knowledge on all of the new healthcare reform, in providing healthcare for small business owners and young entrepreneurs. And before we give Bill's contact information, I want to state that Bill will be a guest on our show next week, and he's going to give all of our business folks the ins and outs of healthcare reform, how it applies to small businesses, the distinctions between healthcare reform the way they are now versus how they used to be, and what the requirements are and what the planning requirements, I should say more specifically, are for business folks who are planning to start a business, not just ones who are in business. So it's going to be a really practical, true to heart show that I think every business owner needs to hear. Yeah. So we're looking forward to having him on next week, I believe, right, Rick?
Yeah, that's right. I'm looking forward to that episode too with Bill. If you're in need of Bill or just want some general information, please reach out to him. That's Bill Pyatt, New York Life, and you can contact him in his office at 949, excuse me, 949-215-7078. He's located here in South Orange County, or email at wfpyatt, that's Pyott, at ft.newyorklife.com. So you can also find him on LinkedIn as well. So reach out to Bill Pyatt at New York Life, and we look forward to seeing him as our guest next week's episode.
Absolutely. I'm looking forward to that myself. I have a number of poignant questions I'd like to pose to Bill. So in any event, getting back to the show, asset protection planning and tax estate planning. They don't always jive. And this is important because is tax planning. And part of tax planning requires you to have one of the three musketeers on your team, right? A business attorney who knows asset protection, estate planning, and employment issues, a marketing guru, and a tax accountant. I just don't see how you can make a business function profitably if you don't have those three people on your team. So let me tell you a little bit about what I'm talking about. Let's say you make gifts to your children and other prospective heirs. Well, that's common in estate planning, and it's used for various tax reasons. Again, that's a subject of another show, but suffice it to say that you can provide gifts to your heirs each year to reduce your tax basis and also to be able to provide them with tax-free gifts. But asset protection planning is not something where you plan to give gifts to people. These gifts can easily be set aside as fraudulent transfers. Oh, well, I'm going to give you this piece of property and I'm going to put it in your name. Well, if the court determines by way of a judgment against you that that was done solely for the purpose of avoiding a judgment, that transfer, that quote-unquote gift can be overturned. So again, going back to potential fraudulent transfers, just remember that asset protection planning is very different than tax estate planning. You can make these gifts in estate planning, but don't think you can make gifts by way of asset protection planning that's going to hide your assets from a potential claim. Because after all, who's going to give a house away for nothing?
Yeah, that's
Who's
true.
going to give a bunch of money away for nothing unless they're trying to hide it from a potential judgment? Now, going back to the first thing I mentioned at the top of the show, if you plan ahead, if you give assets to people like your wife or some other trusted individual way before anything ever happens, if you do this bit by bit by bit when you begin your business, then of course it's done. And it's been done, and there is no claim out there. And then if one comes along down the pike, it cannot be considered a fraudulent transfer. It's just asset protection planning at its core.
The number one rule, like you said before, plan early, right?
Plan early, Rick. Plan early, and do it before a claim arises. We've gotten so many calls on this, and I find it fascinating because it used to be a big thing years ago. But remember, if your money is offshore, you're still here. Your money can be offshore, but you're still here. And recent cases have come down. In fact, a plethora of cases that show that the power of the courts to require debtors to bring their money back to the United States is called a repatriation order. And the court can issue this repatriation order, which if the debtor does not comply with it, a court may issue a bench warrant for contempt of court. And then guess where you end up?
Yeah, right.
Yep, you end up in the who's gal, right? And this can last for many years. Take a man by the name of H. Beatty, Beatty, Chadwick, Chadwick. He refused to repatriate money from an offshore account back to the United States. Been in jail for 14 years.
Oh, my goodness.
14 years. I hope all that money's doing him a lot of good. Maybe his wife brings him carrot cake every week instead of Hostess cupcakes. I don't know. But, these cases, and this is an interesting topic. I could do a whole show on this about offshore, and maybe we will. But it really has to do with the IRS clamping down on outside governments saying, hey, I'm going to make this tough on you in a number of different ways through taxation, visitation, tourism, that kind of stuff. There's ways that the government can put pressure to make these people cooperate. And if a repatriation order is issued, these governments need to comply under many circumstances and say, okay, we're ready to fulfill it, but this guy has to give us our okay. If you don't give him the okay, you end up in jail.
So even
you could end up in jail.
Yeah, I mean, even as glamorous as you hear in the movies about money being stored in a Swiss bank account, it's still reachable somehow, right?
Well, it could be. It could be, yes. Not in all cases, but I've hide your assets and put them in different places, but not hide them. Don't hide the fact that you have bank accounts. Don't hide the fact that you've got corporations and that you're a director or officer of the corporation. There's no need to do that if you do it properly. And how do you do it properly? You do it bit by bit. You start from the beginning. You do it early, and you do it before a what? Claim arrives. That's why I keep harping on asset protection. We're not sitting here saying you need to protect your assets because you're going to be sued. We're saying you need to protect your assets because there's always the potential you will be sued. And I think in the Bottle Business Sense newsletter, one of the things I always say in the tip of the month at the top of the newsletter is you don't have to be in the wrong to be sued. You can be sued and then you end up possibly settling, or you take the case all the way. Not to say that sometimes you're not sued rightfully. You might be. Maybe you did something wrong. Maybe you were negligent. Maybe you intentionally did something wrong, whatever. But the point is, if you if you properly planned your asset protection and implemented it way before any claim arose, well, those things are going to be protected as long as you maintain the company correctly and do all of the other things that you need to do to maintain any accounts that you may have in proper order that contain any of your assets. So please always keep that in mind. These offshore accounts are not as preferable as they used to be. They're not as attractive as they used to be. Another thing I think our listeners and viewers need to be very aware of, Rick, is don't count on bankruptcy court as a refuge of last resort. Okay? Please don't do that. By the way, in 2005, the bankruptcy laws were changed to become a cold acid bath of sorts that leaves debtors with bare bones and little flesh. I mean, it really, really does. Because the new bankruptcy code empowers bankruptcy judges with some of the strongest powers to make debtors up assets. First of all, I'm not a bankruptcy attorney, but I do know that fraud is not something that's dischargeable in bankruptcy. So if you have a judgment against you by way of fraud, that's not going to be discharged. That's different than you having a fraudulent transfer and you're trying to discharge another claim that's not based on a fraudulent court action. Let's say you have a judgment against you for something other than fraud, but you have attempted to defraud your creditors by fraudulently transferring assets. If that becomes known, or if that is sniffed out by a bankruptcy judge, boy, he'll void that action as quick as you can say Rick Moscoso. He really will. So, I mean, these are important tips that I don't think people understand. And again, I really want to, or would commonly be aware of. But I think what's very, 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 very important here is to impress upon everybody, Rick, that planning ahead is critical. Don't do it after the fact, right? You wouldn't try to shoot a video and then put the film in the camera, right?
Yeah, that's right. The point being here, and I think everyone's heard Bill's suggestion, is that, man, the number one rule, like you said, is plan early, plan early, plan early, and plan often, right?
Plan early and plan ahead and do it little by little. Mm-hmm. The last couple of things I want to point out at the close of the show are this. If you can't explain it, it's never going to fly. If you can't explain it, it's never going to fly. Many asset protection plans become so complicated that not even the client can explain how the assets are held or where the assets have been transferred. These questions are going to be asked at a deposition by a smart lawyer, and failure to fully and clearly explain where they are going to raise suspicion. And believe me, when if you're in court and the court suspects something is afoul, they're going to find out. They're going to figure this out. So remember, this goes back a slingshot, maybe effect back to what we were mentioning earlier. Don't try to hide those assets. Be able to explain where they are. And again, would you ever want to hide your assets if you've undertaken the asset protection plan properly? If you've done everything properly, why would you have to hide it? I mean, this is just common sense, folks, right? It's common sense. And finally, I want to impress upon our listeners and viewers that everything usually sees the light of day. Everything usually sees the light of day. And that means that asset protection plans that require secrecy will face a plethora of problems, from how not to disclose the structure and activity on tax returns, how to keep a mad ex-spouse or disgruntled employee from talking to creditors, right? If you do something inappropriate, somebody is going to squeal on you, whether it's the ex-spouse or whether it's the disgruntled employee, Again, now you see an overlap, don't you, between asset protection, estate planning that we've already covered, and now employment law. Okay? So a failure to make truthful disclosures can lead to perjury. It can lead to bankruptcy fraud. It can be a fraudulent transfer that is recovered or reversed when somebody makes a fraudulent transfer claim. And it could end up in contempt of court if you refuse to repatriate assets that are offshore. I mean, you can get into a lot of trouble here. Mm-hmm. That's why we have asset protection lawyers. You know, we're here to keep you out of trouble. Keep you what, Rick? Off the courthouse steps.
That's right.
Right.
The question is for those folks that are even thinking about this, which is beyond me after listening to this episode, is it worth the risk of being housed and moved to the gulag for, for quite some time, or protect yourself early on and take Bill's recommendation and plan early?
Yep, you'll get free rent if you're in jail. You won't have to worry about paying any mortgages or anything like that. And you certainly won't be eating at the 5 Crowns either. So, this is stuff that you need to be aware of. And I know this throws a bit of a chill into some people, but it's meant to, because asset protection is there for people who want to do it the right way, not for people who want to take shortcuts. So, having said that, I think the show today is really meant to provide you with kind of a synopsis of what you should know before you go into asset protection planning, what you should know in terms of the distinctions between asset protection and estate planning. Estate planning is typically not an asset protection tool unless you have an asset protection trust. That can be discussed with me or any other estate attorney. And an asset protection trust, of course, requires you to relinquish ownership of your assets in order to gain that kind of a protective veil. And then don't forget, keep your employees happy. You never know what can happen. Now, the response to that by everybody who's listening should be, well, I don't have to keep my employees happy, Mr. Bernard, because if I do my asset protection properly, I won't need to worry about any of that stuff. Well, that's true, but you want to keep your employees happy anyway, don't you? So you can avoid some sort of an employment lawsuit. It's all about avoiding lawsuits. It's all about avoiding court, and it's all about making sure that you're protected, so that when you go to Rick and say, let's talk about my video marketing plan or my website or whatever else it is I need, he can say, hey, we're going to get you up and running because you are in that bottle. And you're protected in that bottle.
That's right. And,
right, Rick?
And hopefully for those listeners who give Bill a call, we'll be blessed and thankful that it was Bill that is helping them keep them off the courthouse steps. So if you're not and you're in need of help, Bill, how do they get a hold of you?
You can contact my website, of course, is wfblegalconsulting.com. And again, I would urge you to take a look at that. Rick is the handyman who took care of that for me. So my email would naturally be bill@wfblegalconsulting.com. My phone numbers are as follows, both 949 area code. 413-6535 is my personal cell, 413-6535, and my business line is 698-6222, 698-6222.
All right. Well, thank you very much, Bill, for that information. Again, folks, if you are in need of Bill's services, please reach out to him. He knows what he's doing. He knows what he's talking about, and I know I have full faith in him that he'll do the right thing for you to keep you off those courthouse steps. So, with that being said, Bill, any closing statements before we?
Yes, Yes, just to remind everybody again that next week's show will be with Mr. Bill Pyatt, and that Bill will cover the healthcare reform issues that are mandatory and also necessary for every business owner to be aware of. It's going to be a great show because there's not a whole lot of people out there covering this on a daily basis and who are as familiar with it as Bill is. So Bill Pyatt will be on next week. Please join us, everybody. And to close the show, Rick, tell everybody where they can join us.
Yeah, you can reach out to us on social media, of course, Facebook, Google Plus, or you can tweet us at BB Sense Show. If you have any suggestions or any questions or any feedback, or even want to be a guest on the Bottle Business Sense Show, reach us on Gmail at bottlebusinesssenseshow@gmail.com. And of course, our website here is bottlebusinesssenseshow.com. So anyway, looking forward to seeing everybody again next week. Bill, thank you again very much. We look forward to seeing you and hearing from you again next week. And
My pleasure.
Everyone have a great day out there.
Okay, everybody, have a prosperous week. We'll see you next week. Take care now.